Griswold versus Connecticut. This was decided June 7, 1965. Appellants, the executive director of Planned Parenthood League of Connecticut and its medical director, a licensed physician, were convicted as accessories for giving married persons information and medical advice on how to prevent conception and, following examination, prescribing a contraceptive device or material for the wife's use. A Connecticut statute makes it a crime for any persons to use any drug or article to prevent conception. Appellants claimed that the accessory statute as applied violated 14th Amendment. An intermediate appellate court and the state's highest court affirmed the judgment. Held, appellants have a standing to assert the constitutional rights of married people. And that is Tileston versus Ullman. 2. The Connecticut statute forbidding use of contraceptives violates the right of marital privacy, which is within the penumbrum specific guarantees of the Bill of Rights. Constitution 544, reverse. Or Connecticut, I mean. Thomas Emerson argued the cause for appellants. With him on the briefs was Catherine G. Rorabeck. Joseph B. Clark argued the cause for appellee. With him on the brief was Julius Meritz. Briefs of amici curiae urging reversal were filed by Whitney North Seymour and Eleanor M. Fox for Dr. John M. Adams, blah, 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 for Planned Parenthood, Federation of America, Incorporated, by Alfred L. Scanlon for the Catholic Council on Civil Liberties, and by Rhoda H. Melvin, and a whole bunch of people for the American Civil Liberties Union. Mr. Justice Douglas delivered the opinion of the court. Appellant Griswold is executive director of the Planned Parenthood League of Connecticut. Appellant Buxton is a licensed physician and the professor of Yale Medical School, who served as medical director for the league at its center in New Haven, a center open and operating from November 1st to November 10th when appellants were arrested. They gave information, instruction, and medical advice to married persons as to the means of preventing contraception. They examined the wife and prescribed the best contraceptive device or material for her use. Fees were usually charged, although some couples were serviced free. The statutes whose constitutionality is involved in this appeal are Sections 53 to 32 and 54. How's that happen? 53 to 32. Interesting. And 54 to 196 of the General Statutes of Connecticut. And it looks like 1958 reversed. The former provides any person who uses any drug, medicinal article, or instrument for the purpose of preventing contraception shall be fined not less than $50 or imprisoned not less than 60 days, nor more than 1 year, or be both fined and imprisoned. 54 to 196 provides any person who assists, abets, counsels, causes, hires, or commands another to commit any offense may be prosecuted and punished as if they were the principal offender. The appellants were found guilty as accessories and fined $100 against the claim that the accessory statute as so applied violated the 14th Amendment. The appellate division of the Circuit Court affirmed. The Supreme Court of Errors affirmed that judgment. We noted probable jurisdiction. 379 U.S. 926, we think that appellants have standing to raise the constitutional rights of married people with whom they had a professional relationship. Tilson versus Ullman is different for the plaintiff seeking to represent others asked for a declaratory judgment. In that situation, we thought that the requirements of the standing should be strict, lest the standards of case or controversy in Article 3 of the Constitution became blurred. Here, those doubts are removed by reason of criminal conviction for serving married couples in violation of aiding and abetting statute. Certainly, the accessory should have standing to assert that the offense which he is charged with assisting is not or cannot constitutionally be a crime. This case is more akin to Trunz versus Reich, where an employee was permitted to assert the rights of his employer. Pierce versus Society of Sisters, where the owner of private schools were entitled to assert the rights of potential pupils and their parents. I'll have to look at that. And to Burroughs versus Jackson, where a white defendant, partly to a racially restrictive covenant, who was being sued for damages by the covenants because she had conveyed her property to Negroes, was allowed to raise the issue that enforcement of the covenant violated the rights of prospective Negro purchasers to equal protection, although no Negro was a party of the suit. And Meyer, Nebraska, Board of Education, looks like more cases. The rights of husband and wife pressed here are likely to be diluted or adversely affected unless those rights are considered in a suit involving those who have this kind of confidential relation to them. Coming to the merits, we are met with the wide range of questions that implicate the Due Process Clause of the 14th Amendment. Overtones of some arguments suggest that Lochner and New York should be our guide, but we decline that invitation as we did in West Coast Hotel versus Parrish, a whole bunch of others. We do not sit as a super legislature to determine the wisdom, need, and propriety of laws that touch economic problems, business affairs, or social conditions. This law, however, operates directly on an intimate relation of a husband and wife and their physical role in one aspect of that relation. The association of people is not mentioned in the Constitution nor in the Bill of Rights. The right to educate a child in school of the parent's choice, whether public or private or parochial, is also not mentioned, nor is the right to study any particular subject or any foreign language. Yet the First Amendment has been construed to include certain of those rights. By Pierce versus Society of Sisters, supra, the right to educate one's children as one chooses is made applicable to the states by the force of the First and 14th Amendments. By Meyer and Nebraska, supra, the same dignity is given the right to study the German language in a private school. In other words, the state may not, consistently with the spirit of the First Amendment, contract the spectrum of available knowledge. The right of freedom of speech and press includes not only the right to utter or to print, but the right to distribute, the right to receive, the right to read, and freedom of inquiry, freedom of thought, and freedom to teach. Indeed, the freedom of the entire university community. Without those peripheral rights, the specific rights would be less secure. And so we reaffirm the principle of the Pierce and the Meyer cases. The NAACP versus Alabama, we protected the freedom to associate and privacy in one's associations, noting that freedom of association was a peripheral First Amendment right. disclosure of membership list of a constitutionally valid association we held was invalid, as entailing the likelihood of a substantial restraint upon the exercise by petitioners members of their right to freedom of association. Amen to that. I bid, in other words, the First Amendment has a penumbrum where privacy is protected from government intrusion. In like context, we have protected forms of association that are not political in the customary sense, but pertain to the social, legal, and economic benefit of the members. In Schwer versus Board, blah, 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 we held it not permissible to bar a lawyer from practice because he had once been a member of the Communist Party. The man's association with that party was not shown to be anything more than a political faith in a political party, and was not action of a kind proving bad moral character. Those cases involved more than the right of assembly, a right that extends to all irrespective of their race or ideology. The right of association, like the right of belief, is more than the right to attend a meeting. It includes the right to express one's attitudes or philosophies by membership in a group or by affiliation with it or by other lawful means. Association, in that context, is a form of expression of opinion, and while it is not expressively included in the First Amendment, its existence is necessary in making express guarantees fully meaningful. The foregoing cases suggest that specific guarantees in the Bill of Rights have penumbras formed by emanations from those guarantees that help give them life and substance. See Poe versus Ullman. Various guarantees create some of the privacy, the right of association contained in the penumbras of the First Amendment is one, as we have seen. The Third Amendment, in its prohibition against the quartering of soldiers in any house in time of peace without the consent of the owner, is another facet of that privacy. The Fourth Amendment explicitly affirms the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures. The Fifth Amendment, in its self-incrimination clause, enables the citizen to create a zone of privacy which government may not force him to surrender to his detriment. The Ninth Amendment provides the enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. The Fourth and Fifth Amendments were described in the Boyd versus United States as protection against all government invasions of the sanctity of the man's home and the privacies of life. We recently... Oops, where did I just go? Unsure of... Wow, that was weird. But the invasion of his indefeasible right of personal security, personal liberty, and private property, where that right has never been forfeited by his conviction of some public offense. It is the invasion of the sacred right which underlies the Constitution, this essence offered in Mapp versus Ohio to the Fourth Amendment has created a right to privacy no less important than other rights, carefully and particularly reserved to the people. We have had many controversies over these conundrum rights of privacy and repose. These cases bear witness that the right of privacy, which presses for recognition here, is a legitimate one. The present case, then, concerns a relationship lying within the zone of privacy created by several fundamental constitutional guarantees, and it concerns a law which, in forbidding the use of contraceptives rather than regulating their manufacture or sale, seeks to achieve its goals by means having a maximum destructive impact upon that relationship. Such a law cannot stand in the light of familiar principles so often applied by this court, that a governmental purpose to control or prevent activities constitutionally subject to state regulation may not be achieved by means which sweep unnecessarily broadly and thereby invade the area of protected freedoms. Would we allow the police to search a sacred precinct of marital bedrooms for telltale signs of the use of contraception? The very idea is repulsive to the notions of privacy surrounding the marriage relationship. We deal with the right of privacy older than the Bill of Rights, older than the political parties, older than the school system. Marriage is coming together for better or worse, hopefully enduring and intimate to the degree of being sacred. It is an association that promotes a way of life, not causes, a harmony in living, not political faiths, a bilateral loyalty, not commercial or social projections, yet it is association for as noble a purpose as any involved in our prior decisions. I don't know why it says reversed. Mr. Justice Goldberg, whom the Chief Justice, and Mr. Justice Brennan, my judge, joined concurring. I agree with the court that Connecticut's birth control law unconstitutionally intrudes upon the right of marital privacy, and I join in its opinion and judgment, although I have not accepted the view that due process as used in the 14th Amendment incorporates all of the first 8 amendments. See my concurring opinion. Blah, 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 blah. I do agree that the concept of liberty protects those personal rights that are fundamental and is not confirmed to the specific terms of the Bill of Rights. My conclusion, My conclusion that concept of liberty is not so restricted and that it embraces the right of marital privacy through that right is not mentioned explicitly in the Constitution, is supported by numerous decisions of the court referred to the court's opinion and by the language and history of the Ninth Amendment in reaching the conclusion that the right of marital privacy is protected as being within the protected conundrum of specific guarantees of the Bill of Rights. The court refers to the Ninth Amendment. I add these words to emphasize the relevance of the amendment to the court's holding. The court stated many years ago the due process clause protects those liberties that are so rooted in the traditions and conscience of our people as to be ranked as fundamental. For present purposes, we may and do assume that freedom of speech and of the press, which are protected by the First Amendment from abridgment by Congress, are among the fundamental personal rights and liberties protected by the Due Process Clause of the 14th Amendment from impairment by the state. And in Meyer, while the court has not attempted to define with exactness the liberty thus guaranteed, the term has received much consideration, and some of the included things have been definitely stated. Without doubt, it denotes not merely freedom from bodily restraint, but also the right to marry, establish a home, and bring up children. This court, in series of decisions, has held that the 14th Amendment absorbs and applies to states those specifics of the first 8 amendments which express fundamental personal rights. The language and history of the Ninth Amendment reveal that the framers of the Constitution believed that there are additional fundamental rights protected from governmental infringement, which exist alongside those fundamental rights specifically mentioned in the first 8 constitutional amendments. The 9th Amendment reads, "The enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people." The amendment is almost entirely the work of James Madison. It was introduced by Congress by him and passed the House and Senate with little or no debate and virtually no change in language. It was preferred to quiet expressed fears that a bill of specifically enumerated rights could not be sufficiently broad to cover all essential rights, and that the specific mention of certain rights would be interpreted as denial that others were protected. In presenting the proposed amendment, Madison said, "It has been objected also against a Bill of Rights that by enumerating particular exceptions to the grant of power, it would disparage those rights which were not placed in that enumeration, and it might follow by implication that those rights which were not singled out were intended to be assigned into the hands of the general government, and were consequently insecure. This is one of the most plausible arguments I have ever heard urged against the admission of a Bill of Rights into this system, but I conceive that it may be guarded against. I have attempted it, as gentlemen may see by turning to the last clause of the 4th resolution, the 9th Amendment. Annals of Congress. Mr. Justice Story wrote of this argument against the Bill of Rights and the meaning of the 9th Amendment in regard to suggest that the affirmation of certain rights might disparage others or might lead to argumentative implications in favor of other powers. It might be sufficient to say that such a course of reasoning could never be sustained upon any solid basis, but a conclusion answer is that such an attempt may be interdicted, as it has been, by a positive declaration in such a Bill of Rights that the enumeration of certain rights shall not be construed to deny or disparage others retained by the people. He further noted, referring to the 9th Amendment, this clause was manifestly introduced to prevent any perverse or ingenious misapplication of the well-known maxim that an affirmation in particular cases implies a negation in all others, and converso, that they made their point. Sorry. These statements of Madison and Story make clear that the framers did not exactly intend the First Amendment to be specific, is basically what it's saying. The 9th Amendment of the Constitution may be regarded by some as a recent discovery and may be forgotten by others, but since 1791 it has been a basic part of the Constitution which we are sworn to uphold, to hold that right so basic and fundamental and so deep-rooted in our society as the right of privacy in marriage may be infringed because that right is not guaranteed in so many words by the first 8 amendments to the Constitution is to ignore the 9th Amendment and give it no effect whatsoever. Nicely said. Moreover, a judicial construction that this fundamental right mentioned in explicit terms by one of the first 8 amendments or elsewhere in the Constitution would violate the 9th Amendment, which specifically states that the enumeration of the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. I think that is all.